Hi, Karen here. Today I'm really excited because today I'm going to be breaking down clips of American movies and legal dramas all about criminal law. I've been a full-time criminal prosecutor and criminal defense counsel for over 20 years now. As you may know, I am actually a qualified lawyer from Ontario, Canada, and I'm also a qualified barrister here in England and Wales. I did pass the New York bar, but I do not consider myself an authority on American law at all.
The trial is outrageous. It is a waste of the taxpayers' time and money. It is a travesty of justice that these four people have been incarcerated. You know what these four people were? They were innocent bystanders. Now, you just think about that term. Innocent bystanders.
Liar, liar. Announcing the judge.
Rise for the Honorable Judge Marshall Stevens.
Honorable.
Liar, liar, one of my favorites. This again is something that's very American. They announce the name of the judge when the judge is walking in. Canada and the UK, that does not happen. I think one of the reasons why it happens in the States is because judges are elected, just like the prosecutors and sheriffs and all these sorts of positions. In the US, they also have the nameplate of the judge in front of them. I think it's to help them get reelected, because if that name comes out and people listening to them are familiar then with the name, if it appears on a ballot then to be reelected, then people are familiar with that name.
And you, Mr. Reede?
I'm a little upset about a bad sexual episode I had last night.
Well, you're still young. It'll happen more and more. In the meantime, what do you say we get down to business?
Law-abiding citizen, bail hearing.
In light of Mr. Shelton's economic means and his potential flight risk, the egregious nature of both Mr. Ames and Mr. Darby's deaths, the state requests that bail be denied, Your Honor.
When you're at a bail hearing and there has been a very violent situation, regardless of how serious the offense is, unless you have something linking the alleged defendant to the actual offense, just saying that the crime is serious is not going to be sufficient to keep someone inside. You have to show the bail court that there's a link between this serious offense and the person being charged with it. You would never have a bail hearing if you didn't have any evidence of it. Regardless of how serious the offense is, you can only say that seriousness of an offense is a bail factor once you have shown the link between the offense and the person being charged with it.
Seeing as how you've waived your right to counsel, Mr. Shelton, do you have anything to say? Mr. Shelton? Do you have anything that you'd like to say, Mr. Shelton?
Yes, Your Honor. Should I stand?
Please.
Your Honor, I'm a law-abiding citizen. I'm just a regular guy. I am not a flight risk. And this is my first alleged offense. And the prosecution has not presented one single piece of evidence against me. Now, in these circumstances, unless the state has obtained some new piece of information relating to my involvement in the matter in question, then I find it highly prejudicial, even constitutionally offensive, to keep me detained without bail. It's a slippery slope, Your Honor. Haven't we seen the result of such violations both internationally and domestically? Case in point would be Day v. McDonough, docket number 041325.
The submission being put here is a valid one. If there's no evidence linking him to the crime, they should not be even in bail court, never mind arguing for his detention.
I am actually inclined to agree with you, Mr. Shelton.
Your Honor, Mr. Shelton has agreed to give us a full confession.
Has he given it, Mr. Rice?
No, Your Honor.
Again, I don't know American law, but I have heard that sometimes they get away with things like that. And some of the things that I've seen on TV of real-life crime dramas, they do actually make submissions like that in the bail courts or to the judges. Now, in Canada and the UK, that would not be allowed. You don't say, we think this is going to happen. He did agree. That would be entirely inappropriate. Also remember, you've got a prosecutor standing up there saying he agreed he was going to confess to this crime. And that's in an open court with people sitting in the gallery. Can you imagine the gravity of that? Especially if it's a serious offense, which he said that it was. The press would be right on that. That would be entirely inappropriate.
Well, then, in my opinion, the state has failed to establish a compelling basis for its motion, and I will grant bail.
And he got bail, and according to the evidence before the court, that would be perfectly legitimate.
I'll caution you not to do that.
50 Shades Freed.
Does your client deny forcing entry into this penthouse?
He does not, Your Honor. However, my client merely wanted to confront the parties responsible for destroying his career.
I think he wanted to do more than confront them, Counselor. However, given his clean record, the court will grant bail.
This is very, very common in Ontario and in the UK. Whether someone is going to reoffend is an issue. If someone's going to escape or has the means to escape is going to be an issue. And of course, safety of the alleged victim of crime or possible victims of crime is going to figure very, very heavily whether someone's going to be released or not.
Set at $500,000.
$500,000 bail, that is definitely an American thing. They set these huge bails, even $5,000, $50,000, $100,000. In the UK and in Canada, we sometimes will set bail and somebody will guarantee a certain amount, but that money's not paid unless the person does not show up for court. So it's not as if it's got to be money up front, but the amount of money that is in the American court system is completely and utterly out of whack with what happens in the UK and what happens in Canada. In Canada and the UK, we don't have bail bondsmen, and we don't have the bail sold to private companies and people come after you. We don't have Dog the Bounty Hunter.
I am a lawman on a mission from God.
We don't have any of that. No dog.
You, sir, are fired.
No dogs allowed.
Goodwill Hunting. A defendant representing himself.
Beecher in Proverbs from the Plymouth Pulpit, 1887, said, and I quote,
This is 20th century, Your Honor. It's going to make a mockery of the court.
I am afforded the right to speak in my own defense, sir.
Here we have Matt Damon representing himself. He is absolutely right. He is allowed to represent himself. I can say the other lawyer interrupting him would not be allowed in Canada or the UK. The judge would intervene and would tell the lawyer to sit down and be quiet. If anything, in Canada and the UK, more respect is given a defendant representing themselves and more latitude is given.
By the Constitution of the United States, this is the same
Don't tell me
document
about
which
the
guarantees my
Constitution of the
liberty.
United States.
Now, liberty, in case you've forgotten, is the soul's right to breathe. And when it cannot take a long breath, laws are girded too tight. Without liberty, man is a cinco.
Man is a what?
Ibid, Your Honor.
When Matt Damon says ibid, Your Honor, what that means is that he's referring to a case that he had already just referred to. I have never heard it used that way. Again, maybe they do that in the States, I don't know. But in Canada and the UK, if you're referring to a case that you've already referred to, you would write ibid in your footnote in a written document, but you wouldn't say ibid in a courtroom. What you would say is, further to the case I mentioned earlier, and then you would say what the principle is. I have never, ever said or heard ibid being used in a Canadian or a UK courtroom.
Sitting here for 10 minutes now looking over this rap sheet of yours. I just can't believe it. June 93, assault. September 93, assault. Grand theft auto, February of 94. Where apparently you defended yourself and had the case thrown out by citing free property rights of horse and carriage from 1798.
In the UK and in Canada, when you get a typical criminal record that's printed off and put in the police file, which would be before the court, it would not contain the level of detail that this judge has just read out. If someone's acquitted of an offense, they just put acquit. They don't put that they represented themselves, and they don't put that the acquittal was based on this particular old case. That's just not realistic. That just is not happen at all. There are different levels of criminal records that you can get. You can get the sort of bog standard criminal record that shows convictions, the sentence, the jurisdiction of where the conviction was, but you can ask, I've asked sometimes as a prosecutor, get me the sort of behind the scenes of each of these convictions, and I can get more details of what the conviction was actually for. So if it just says assault on the criminal record, I can get a more in-depth criminal record run, which would actually give me the type of assault. Was it a domestic assault? Was it a bar fight assault? Was it a random stranger being attacked on the street assault? So I can get that kind of detail if I get a more in-depth criminal record, but that's not the normal record that's run. And certainly, again, that would not be found at all in a Canadian or a UK criminal record, full stop.
You know, another judge might care, but you hit a cop, you're going in. Motion to dismiss is denied. $50,000 bail.
Thank you.
Roman J. Israel, Esquire. Calendar call.
What do you have on number 32? Langston Bailey.
The prosecutor is doing here is what they call in the States calendar call. We don't have that terminology in the UK or in Canada. We do have obviously a very busy courtroom where people that have just been arrested or kept in custody may be pleading guilty. We have very busy courts, but we would just have a pile of courts, or we'd have bail court. Now, the defense counsel would definitely approach a prosecutor if they had a client that they wanted to talk about to discuss sentencing. That also does happen in Canada and in the UK.
He has one prior minor offense.
And with one prior minor offense, that clearly is going to go into the decision making by the prosecutor as to how much time that they're going to get. This is much more the Ontario sort of model than it would be here in the UK. In the UK, these conversations are not as frequent. I should add, by the way, that in Ontario, I'd say I can't speak for all of Canada, but in Ontario, these conversations would not be conducted in an open courtroom where everybody can hear you. We would have a little anteroom off of the side of the courtroom, and I would sit there with a police officer who'd hand me the files and would be able to tell me some of the information about it. But I would be scanning these files very quickly, and the defense counsel would come in and they would talk to me about their client or two or three of their clients, and we'd go through each of the files, and I would have a guess as to what sort of sentence I would be looking at. If it's too complex, then I'd put it aside and think about it.
He pleads to count one. I'll tell the judge and request the minimum 5 years. He's facing 15 at trial.
For a 17-year-old breaking and entering, I mean, hell, why don't we just get it over with and shoot him?
When it comes to custody, it is definitely an American experience to have high custodial terms. I was reading a BBC article that quoted statistics from the International Center for Prison Studies, and it showed that in the States, they lock up 737 people per 100,000 population. The UK locks up 145 per 100,000. Scotland locks up 134, Northern Ireland 79, and Canada locks up 188. The US has 5% of the world's population, but has 25% of the prison population in the world.
Talk to your client. My conviction rate's 100%.
All rise.
Also, too, if you have a 100% conviction rate, you know what that tells me? She doesn't do a lot of trials.
Court of District 9 is now in session. The Honorable James Hurricane is presiding.
Objection?
Bye for now.
We'll be out in a year. And then we'll be back. Could be fun. Don't have to worry about your meals or what you're gonna do Saturday nights. And they do shows. Yeah, we could put on a show. Maybe Bye Bye Birdie or My Fair Lady. Yeah, Elaine. You could be Liza Doolittle.
Why don't you just blow it out?